Please be seated. So for our next case, State of Texas versus Synad Limited. May I have appearance for the State of Texas, the appellant.
Yes, Your Honor. I'm Lisa Mitchell for the State of Texas.
And you intend to divide your time?
Yes, please. 10 minutes with 5 rebuttal.
And for the appellee?
Good afternoon, Your Honor. So I'm Richard Rothfelder, here with my co-counsel, Chris Rothfelder, representing Synad.
You two related?
Yes.
I put that together all really quickly, so that's it.
Thank
All
you,
right.
Your Honor.
When you're ready, Ms. Mitchell, you may proceed.
May it please the court. The state asked this court to reverse the trial court's award of nearly $220,000 in dismissal fees and render judgment in favor of the state of Texas. We state several reasons in our briefing. I'm going to focus on 2 of those main reasons today. First, Synad did not own property in the state's right-of-way. And second, Synad is not entitled to costs that were incurred before the condemnation petition was even filed.
Does Synad ever own property that was in the state's right-of-way?
They did until they moved it.
And so how long had they owned it prior to it being moved?
Oh dear. Many years. I want to say maybe about 50 years or so. They've been there a long time.
So they owned the property, then the state condemned the property?
They owned the sign that sat on property that was a railroad easement. But yes, the state was going to condemn the sign, not the underlying property, since that was a railroad easement. But yes, they did own the sign, and some of it encroached into the state's right-of-way, and so the state was going to get the sign.
So was there at some moment where the state incurred liability to Synad?
No, because they moved the sign out of the state's right-of-way before there was ever a condemnation case. So as I mentioned, there was no property in the right-of-way that was owned by Synad during the condemnation proceedings. Synad has sought its fees and expenses under the Texas Property Code 21.019 and .0195, the latter applying directly to TxDOT actions only. But both of those sections they serve to protect the public from condemnation cases that maybe could harm them in some way. I'm going back and forth with my glasses, sorry. Basically, the purpose of those sections is to protect property owners for the time that the condemnor might have held their property, for any damages that could have been caused to the property, or for any fees that the landowner or property owner incurred in connection with the proceeding.
With regard to that, counsel, you agree that Synad did have to incur fees or costs to move the sign, whether or not it was because of the state's instructions. They did move the sign out of the area that was being condemned, if you will.
They did incur fees pre-condemnation. Those are not compensable fees. That never is the situation. We cite a case in our briefing that goes directly to that point, that if you move the subject of the condemnation prior to the condemnation, you're not entitled to damages for that. And I believe that's the Austin Livestock case, or Capital versus Austin Livestock case. So typically, if the state ends up dismissing a case, voluntarily dismissing a condemnation case, it's usually for something when there's maybe a change to the rights the state is seeking to acquire, or if it's filed in the wrong kind of court, because there are some different rules about which court to file in. But this was anything but a typical case. Here, as we're talking about, Synad moved its sign out of the state's proposed right-of-way before the state ever filed its condemnation petition. So it wasn't a property owner, as required by the statute, to recover these fees. And this kind of case has been very recently decided by the 13th Court of Appeals as well. It's the State versus Hidalgo Irrigation District number 16 case that we also talk about in our brief. And we would urge this court to follow that Hidalgo reasoning. In that case, the state filed a petition that included the irrigation district, and after discovering later the irrigation district wasn't a landowner, it amended the petition to exclude the irrigation district, and the irrigation district sought its fees, much like has happened here. The court in that case, and when they looked at this case, they looked at section 21019 and 21095, and if you look at the opinion, in every instance that occurs, they've gone through and italicized and emphasized property owner, property owner, property owner, because in order to recover fees under those sections, You must be a property owner.
Now, this was a fixture on the property, wasn't it?
Yes, Your Honor.
Doesn't that make it property?
It's property, but it was removed out of our right-of-way before there was ever a condemnation proceeding filed. So in the irrigation district case...
Excuse me, counsel, but when the state filed the condemnation proceeding, it did believe that the property was in the right-of-way, correct?
It believed that, but it was not. That's correct, Your Honor. In the irrigation district case, basically the court concluded...
Should Sinad have just not defended it then?
I'm sorry, I couldn't-
Should Sinad have just defaulted in the lawsuit then?
No, they shouldn't have defaulted in the lawsuit, but it would have been appropriate for them to tell the state, we've moved our property that is the subject of this condemnation out of the right-of-way. They did it 2 months before we filed the lawsuit.
Did they have an obligation of candor to the tribunal?
I would suggest that they do. It would certainly help. I mean, in other cases where TxDOT has a potential condemnation and folks find out about it, a landowner finds out, or somebody who owns a piece of property or personality, a lot of times people will move their property to avoid the condemnation because they don't want to go through it, they don't want to have to deal with that. And that's not an unexpected thing to happen, but in this case, we weren't told about it. And so it's kind of a strange question you might ask yourself, well, if they were so eager to move their sign out of the right-of-way to avoid condemnation, why didn't they tell us when they moved it?
Does the state not have any obligation before it files a condemnation proceeding to confirm whether or not a condemnation proceeding even needs to be initiated?
Certainly, Your Honor, it does, but it also doesn't have an obligation to expect someone to move its property out of the right-of-way and never say anything, particularly in this instance where Sinad was working with the state to try to get it moved out of the right-of-way for several months. They were seeking a permit amendment to do that, which is the subject of a completely separate action. And so to tell us for months and months, well, we're trying to get this out of the right-of-way, and then they achieve it, but don't mention that they achieved it, and then we go ahead and go through this condemnation proceeding.
Is there a statutory requirement that they make that disclosure, or a regulatory requirement, or a common law requirement? Setting aside common sense or what one would expect, is there something we can point to that says they were legally obligated to make that disclosure to you?
Not that I'm aware of. So turning back briefly, just quickly to the Hidalgo case, because I do think it's very instructive in this situation as well. The analysis was ended for the court when they said, okay, irrigation district, you don't own any property here, you've conceded that, that's enough. We don't have to even go any further in this, and we're not going to expand the statute to allow payment to those without an ownership interest in the subject of the condemnation. Similarly,
In that case, and hopefully I remember it correctly, and correct me if I'm wrong, I thought it was that they never owned. There was not a situation like this where it was and then it wasn't. Is that right?
that's correct, but for purposes of what we're talking about in terms of the fees, it makes no difference, because if there's no property ownership in the state's right-of-way, they can't qualify under the statute to get those fees back because they don't own property there during the
Well,
condemnation.
it's sort of like, depends what the definition of is. At one point, Sinad was a property owner, but at some point became not a property owner. And at what time do we make that determination? They are a property owner. They did own something that was in the state's right-of-way that the state sought to have removed, and then it was removed.
You make that determination at the point we filed that petition for condemnation. I mean, they did not own when we filed the petition.
Okay, well, working through that, an action or a cause of action, one exists independently of the filing of a lawsuit. So if the state has an action for condemnation, or I'm sorry, a cause of action for condemnation, but has not yet filed an action for condemnation, is there anything in the case law or the statute that can point to that fine-grained distinction?
I'm not entirely sure I'm completely following your question, but the bottom line is they have to own at the time to get those fees. So I'm probably not answering your question. I'm sorry.
Well, you said that they have to own at the time of the filing of the lawsuit, or is it do they have to own at the time that a cause of action accrues for condemnation, like when the state initially wants to get the property?
Well, if they own it at the time we initially want the property, fine. But if you go and move it out of our right of way, you don't own it when we file the condemnation, there is no property then that is part of the subject of that condemnation, so they can't get any fees. They're not involved in the condemnation proceeding if they don't own anything.
But we're just looking for, there's not a lot of specific guidance on
There's
this
not.
issue. So, I mean, conceivably, it could be that you're entitled to, that, there's entitlement to fees at the time the judgment is signed, the judgment of condemnation. Or conceivably, it could be when the lawsuit, the action is filed. Or it could be when a cause of action accrues, when there is something, an impediment in the state's right of way. And we're just trying to figure out if there is any authority to help us choose between those three options.
Hidalgo is as close as I'm getting. At the end of the day, they didn't own property in the right-of-way throughout the entirety of the condemnation proceeding, and I'm defining that by the date we filed the petition, which was October 8th of 18, I believe, and then through the time that the state non-suited, which was December 20th, 2019. Nowhere in that time frame did they own any property in our right-of-way, so that's how I'm defining it. If I may very briefly just say quickly to the second issue that I was going to discuss, and I'll use more in rebuttal. SINAD also isn't entitled to reimbursement of those costs we talked about when they moved the sign prior to the condemnation proceeding. And that's because it was before the petition was ever filed. I believe I cited a case about that as well, so I will sit down since my time is up, but that was the other issue I wanted to address.
All right, thank you. Mr. Rothfelder?
May it please the court.
Yes.
Let
Let's
me
talk
focus-
about non-suits first.
Yes.
All right, don't non-suits restore the parties to the position before the filing of a suit?
They do.
And then how do you become a prevailing party after a non-suit?
Well, you are correctly focusing on the central issue in this case. When was SINAD a property owner? And there's a variety of different dates. And the statute is unclear. The case law, the regulatory issues, and the statute don't define when does the party that is seeking its attorney's fees and reimbursement of expenses in connection with the condemnation proceeding, when does he have to be a property owner? Because there's a variety of dates here. She said that she defines it during the course of the condemnation proceeding, but what's that? This issue will be dispositive of the result in the appeal. Because once again, it's made clear, because the state conceded it, that SINAD did own a sign that is considered compensable property under Texas law. It's undisputed that SINAD removed the sign from the anticipated right-of-way and eliminated the encroachment in anticipation of litigation in order to avoid going through the condemnation.
Was that done
So-
with permission of the state?
Pardon me?
Was that done, when you moved the sign, was that done with permission of the state?
No. We didn't need the permission of the state. We got the permission of the local municipality, Sealy, and secured a permit to do so.
So if we assume that the ownership question starts before the actual proceeding and is when the cause of action accrued, when SINAD was notified that it was encroaching on this right-of-way, then, and if we assume that that's true, why does SINAD get any attorney's fees after the initiation of the condemnation proceeding if SINAD knew that it had already remedied the issue?
Because the state continued to seek acquisition of the sign throughout the entirety of the condemnation proceeding.
Why didn't SINAD let the state know that it had done that?
It did so.
When?
That's a disputed issue.
When did it? when did
Before
SINAD
the
let-
state filed a petition, and that petition was filed, I believe, in September 2018. And the month prior to the filing of the petition, counsel for SINAD sent an email to counsel for the state saying that the sign was not in the right-of-way. It followed up again at the special commissioner's hearing and actually provided a survey demonstrating that the sign did not encroach on the state's right-of-way.
Did you tell
And-
them that you'd moved the sign?
We did not do that, Your Honor.
Can I ask you a question?
Yes, sir.
Are there times when failure to make disclosure of material fact is equivalent to an affirmative misrepresentation?
Not under this statute. There certainly is no mens rea, bad faith, or any other requirement from the property owner to have a particular state of mind in order to recover under that mandatory statute for recovery of attorney's fees and expenses incurred in connection with the condemnation. Really, the issue here is simply on these various dates, like in 2017, when the Texas Transportation Commission filed the minute order to
So
authorize the project.
which date are you suggesting we choose?
Really, you can choose any date, but clearly we know that when the condemnation proceeding was authorized, Sinad owned the sign. When the state made its original bona fide offer to purchase the property, Sinad owned the sign. When Sinad moved the sign out of the right-of-way to accommodate the state's project, it owned the sign. And every other relevant date or event thereafter, the special commissioner's hearing, when the petition was filed, when Sinad filed its request for attorney's fees, the state still had in its life pleading an allegation that it was seeking to acquire the sign in eminent domain because
Right,
it still
so
encroached on the
that
right.
that was in the state's original petition.
And in their amended petition also
And in their amended
filed.
petition. So did you specially accept, did you deny that allegation? How did Sinad answer that? Did they file a general denial? And if they generally denied it, wouldn't that be a denial?
In condemnation, a general denial is not typically filed.
Right.
What we did in this case was we filed a motion to dismiss for lack of public necessity because we urged that the sign was not located in the state's right-of-way, and as such, there was no public necessity for the removal of the private property to accommodate the public project of the highway widening. And the state admits that before that February 2019 temporary injunction hearing that they had personally gone out and inspected the sign in response to our notifications that it was not in the right-of-way, and they knew and confirmed in the record that 3 weeks before the temporary injunction hearing that the sign indeed did not encroach. But they didn't amend their petition to drop the sign from the condemnation. In fact, they went forward at the temporary injunction hearing and still contested our motion to dismiss and didn't
But
dismiss
didn't Sinad had superior knowledge to the state, didn't it?
By this time, Your Honor, the state had gone out and inspected the sign and knew very well there was no encroachment in the right-of-way.
When did you, Sinad, disclose to the tribunal that you'd moved the sign?
At the February 2019 temporary injunction hearing.
And when did they dismiss?
In December 2019, almost a year later. And they continued to seek condemnation of the sign in their live petition until the date in December 2019 that they finally dismissed the case. And without dismissal of the case, Sinad is relegated to either going to trial and seeking reimbursement of these some $50,000 that it incurred in shifting the sign some 10 feet away from the right-of-way in order to accommodate the highway project. And they indeed did seek to prepare for trial by setting the depositions of the state's representatives who had claimed that they'd been tricked somehow, because we were going to depose them on this issue of bad faith. Notice that we had removed the sign, even though they now knew that the sign had been moved.
Just to clarify the dates, when did you move the sign?
Pardon me?
What date did you move the
We
sign?
moved the sign in August
And
2018.
you waited till February the
And-
following year to disclose that fact?
Well, no, we told them right after the sign was removed that there was no encroachment on the right of way. Now, let me make clear, because I don't want to be cute here on this. We told them repeatedly in writing that the sign did not encroach on the right of way.
Why didn't you just say we moved it?
We sent them clear indications
Well,
that it
right,
did not
so
encroach
let's-
on the right of way. We did not say we did it. And then there's no obligation for us to say that
Well, that's
we were the ones
that's not
that did it.
necessarily true, because a duty to disclose does not arise generally absent some special relationship between the parties, right? Fiduciary relationship, something like that. But it does arise in a situation where you have a partial disclosure, where there is an obligation to fill in the rest of what you're saying. So the emails between the state and Sinai say, state says, sign's in the right of way. Sinai says, no, it's not. Which is a true statement, but it's only a partial disclosure. It's saying it's not, we know it's not because we moved it. And couldn't this whole thing have been prevented had Sinai disclosed at the time, we moved it? Would that have solved the problem and we wouldn't be here now?
I think not, Your Honor, with respect, because the state finally did undertake, I think, its corresponding obligation of due diligence on its own as the state agency to take the notices that we provided, including providing them a registered survey indicating that the sign was not in the right of way, and to go out and look at it themselves.
When was the survey provided by Sinat? Showing
In
that the,
December 2018, before and at the special commissioner's hearing.
Right. Couldn't you have just said, we moved it? Rather than.
Your Honor,
Because
to not be cute, of course we could have.
Right, and would that have solved the problem? I mean, I understand. So what's coming up is, it's just a dispute about whether it's in the, our survey says yes, your survey says no. Well, we've got to sort this out in the course of a lawsuit, right? But if you had just affirmatively said, we moved it, so state your survey is now out of date, that would have solved the problem. So I'm having trouble with the idea of someone being entitled to attorney's fees because they did not fully disclose that they had taken this action.
I understand, Your Honor.
And
The state indeed did finally undertake due diligence themselves. Now, I mean, we can point the finger at Sinat for not affirmatively stating beyond providing the survey and stating that the sign was out of the right of way. We can point the finger at them for not going on and saying, and we did it ourselves, but we did it during the week, during the day, over about a week and a half period of time, without trying to hide anything, and we told the state, and it took them over a month later for them to go out and finally look at it, and they confirmed that the sign was out of the right of way, yet nevertheless, 3 weeks later, attended the temporary injunction hearing to prevent the condemnation, even though they knew it was not in the right of way. And indeed, they never even amended their petition to cease acquisition of the sign through the eminent domain process until the day that they dismissed the case, almost a year later, in December 2019. Now, there's no obligation under the statute on the property owner for some sort of mens rea, good faith.
understood, but on the other hand, I mean, I don't know how many, what the acreage of properties Sinat. I know y'all are a big company that owns a lot of outdoor advertising, but but the state has millions and millions of acres of easements to manage, and perhaps may not be as nimble as an actor as an economically motivated for-profit corporation that sells advertising. And it just seems to me that in that balance, that if the for-profit corporation that sells advertising has some knowledge that could forestall or cut off needless litigation, that they could perhaps be a little more forthcoming with it. And I don't know where this falls down legally in terms of the duties, but I just have trouble with it equitably.
And I think that is a valid point to be right up front about it, between the time that the sign was moved and the time that the state discovered. But remember, they went out and admitted they knew from their own inspection as early as January 2019, and they didn't dismiss the case until a year later. The court, Judge Leedy, prepared an order that showed when the attorney's fees that he found reasonable and necessary in the case on a month-by-month basis. Surely by the time that the state found out that they were continuing to seek acquisition of property for eminent domain that was no longer an encroachment on their public project, surely they had no reason to continue to prosecute the case, but they did. And they continued to seek the sign through the eminent domain
We're
process.
familiar with the record and the timing, but yeah, so is there, and I'll ask the same question of you that I asked earlier, which is there a statute or a regulation or rule of law that could tell us at which point we make this determination of property owner?
There's not, but let me just conclude by the case law, because the case law is clear in this area interpreting the statute, and that includes the Texas Supreme Court case in the FKM partnership case, that the statute is to be liberally construed in favor of the landowner. And I'm quoting now from the CPS Energy case, that the statute is to be liberally construed in favor of the landowner, to use the words of the court, as the legislature intended to require condemnors to act more responsibly and fairly.
Right, but there's just
Towards the
nothing that
landowner.
says specifically what date. No statute that says we choose one.
There's
date.
not.
Okay.
But to the extent that we don't have anything in the statute, and we have something of an uncommon factual situation here, those cases, Brazos County, CPS Energy, FKM Partnership, made it clear, and I'm quoting here, that in the uncommon factual circumstances of these cases, the statute should be interpreted to make the state act more responsibly and fairly to landowners, so that they don't bear the burden of expenses incurred in anticipation of eminent domain, like clearly happened here. And the attorney's fees for
We should liberally construe the statute, but we don't need to foolishly adopt a rule of law that risks the public fisc. So, are there any other questions from him?
Thank you.
Okay, we've covered a lot of ground, so I'm going to try to do this as quickly as possible. So, you've hit it on the head. Why did they not just tell the state? It would have avoided every single thing that we have just come to talk to you about today. And if SINAD, was so eager to move the sign so it wouldn't be condemned, why wouldn't it tell us? Well, I mean, we haven't gotten into it too far, and I don't want to go too far into it because it's a separate matter. But the obvious reason is because the state had told them previously, you may not get an amendment to move your sign. And so they say in their briefing, we made the business decision to take that up at SOA. And there's a separate proceeding going on for that. And so they made a business decision when they didn't like the decision of the state to move their sign anyway. That's the plain and simple. So to turn to some of the points that were made, there was a permit needed from the state to move the sign. That is true. The city of Sealy is not authorized to give such a permit. That's in our briefing. It's also in the record. SINAD, made these business decisions, and they didn't let the state know. There were murmurs about the communications in September of 2018, and then we filed our petition in October of 2018. And we filed it, I believe, October 8th. The first time we saw the survey, and I use that term loosely, was apparently on October 11th. There is dispute in the record, as you know, as to whether we got it, whether we received it, whether we saw it. Regardless, at the special commissioner's hearing, it was presented again by Mr. Rothfelder Jr., or Chris Rothfelder, And the commissioners wouldn't consider it. They refused to consider it. So it's not as if this has been trotted out lots of times and everybody's seen the survey. And really tellingly, and also in the record, in the testimony, Sinad's own president couldn't read the survey. He was being examined about things on the survey, and he was having difficulty reading it himself. So this survey really shouldn't get a lot of weight, since even the president of the company couldn't necessarily read it. With respect to when the state first knew, you heard January or February of 2019 was the first time the state knew anything. The sign was moved about 6 months prior. Had we amended the petition, we would have effectively non-suited the case, which is what we were trying to avoid doing, so we wouldn't have to pay fees. I mean, that is how this works. Now,
So why did the state wait so long then?
because Sinad said at least 3 times in objections at Clerk's Record 87, at the injunction hearing, Second Reporter's Record 11, and in its supplemental application for temporary injunction that was filed on April 12th of 2019, which is in the Clerk's Record 148 to 55. Each time Sinad said it was going to dismiss this case if the sign was not in the state's right-of-way. Well, they knew the whole time. Every single time they said this, they knew they had already moved the sign. So we're in a situation where, yes, this could have absolutely been avoided. And while there may not be a legal requirement that they tell the state, I think the taxpayers would really appreciate not having these condemnation cases brought and lots of money spent where there doesn't need to be, and where they've already kind of self-helped and self-corrected the problem themselves. So they're certainly not entitled to be reimbursed for any of that or these attorney's fees. And really, at the end of the day, if this court decides, you know, we're going to uphold this award of these fees, the message is essentially the state ends up getting fined for not, as they say, doing its due diligence. But again, I submit to the court that the state doesn't have a reason to walk around believing all the time that landowners are just going to move things out of right-of-way. I mean, we do surveys. We do go out and look at the properties before we take properties in acquisition. And it's not something the state should have to expect that they're going to be duped by every landowner they come across.
Is it perhaps a jury question to determine what diligence is due?
No, because this comes down to a legal question, and the legal question that the court needs to decide is whether or not they were an owner under the statute. I mean, this is a straight up legal question for you to decide de novo. And it's just not there that they were properly an owner. And for those reasons, the state requests that this court please reverse and find in favor of the state, do not allow any fees to be awarded, do not allow the cost to be awarded for the sign that was moved prior to the condemnation. This condemnation.
Would you agree, or would the state agree, that if Sinad had moved the sign, let's say the day of or the day after the state initiated the condemnation proceeding, that then Sinad would have been entitled to those costs?
I'm sorry, you said on
if Sinad had moved the sign the day of or the day after the initiation of the condemnation proceeding, would they have been entitled to those costs?
I think it would have been a different argument for sure. We'd be in a different posture. I don't think they would have been entitled to everything they got from the trial court. I think they maybe would have just been entitled for, again, what they had accrued from the beginning of the condemnation period. Because normally in these cases, and I see I'm over so quick, normally in these cases, you know, lawyers don't even really get hired until we filed our petition for condemnation. So that's really when your billing would start. So it would be a different calculation. But I mean, yes, they might be entitled to some of it because it was a condemnation proceeding in which they owned property still, but they didn't.
Any further questions from the panel? Thank you very much, Ms. Mitchell. Thank you, counsel. Cause number 01200075CV, State of Texas versus Sinad, is now submitted, and the First Court of Appeals is now adjourned. Thank you.
All rise.